Good morning, everyone, and welcome to this morning's webinar brought to you by Good Roads and Borden, Ladner, Gervais, LLP. For those of you who don't know me, I'm Thomas Barakat, and I'm Good Roads' Manager of Public Policy and Government Relations, and I will be serving as your host this morning. As you all probably know, on October 21st, 2021, the Supreme Court of Canada released its decision in Nelson versus Marchi 2021, providing insight into the court's analysis of core policy immunity in the context of specific challenges to the winter maintenance decisions of the city of Nelson, British Columbia. Joining us today from Borden, Ladner, Gervais to break down what this all means are Kevin McGivney, a partner with the firm, and Sarah Sweet, a senior associate. Before we get started, just a few housekeeping items. The presentation will run for, I think, 45, 50 minutes type thing. And then at the end, we're going to take questions. So please submit your questions throughout the presentation, and we'll try to get through as many of them as we can. So without further ado, please welcome Kevin and Sarah.
Good morning, everybody.
Morning, everyone.
And thanks for joining us. I'm going to kick it off. As Thomas indicated, my name is Kevin McGivney. I'm with Borden Ladner, focused large measure in my practice on municipal liability for a good number of years. And I have to admit that it's not frequently the case that we see the Supreme Court of Canada addressing itself to winter maintenance issues and roadways. So I think there was a lot of interest, a good deal of interest when the decision came out. Frankly, a lot of interest that a lot of the press coverage suggesting that this was possibly going to expand the scope of liability for municipalities, and that this would be something that we would have to be addressing going forward. I'm going to suggest to you, and we'll take you through this, but at least insofar as Ontario is concerned, we're not really persuaded that this decision is going to make a great deal of difference at all. It's really a restatement of law that already existed. And in large measure, it doesn't address itself to the liability regime for roadway maintenance in Ontario in any event. And we'll get into explaining a little bit of that. Sarah's, after I give a little bit of context, Sarah is going to take us through the decision. I'm then going to refer to another Ontario Court of Appeal decision that hopefully gives some further context for you. And then we are happy to take questions at the end. So very interested in hearing what you have to say, any thoughts or concerns that you have. So just so I start and give this some context, there are effectively in Canada two sources of, two streams, I suppose is the way to put it, of where a public authority can be held liable in negligence. The first is what we would call the common law stream. So common law negligence against a public authority. And this kind of harkens back, not to get too much into a history lesson, but it does get referenced by the Supreme Court of Canada in its decision that historically it was not possible to sue a public authority for negligence. There was this theme that all citizens are in this together, and effectively allowing a citizen to sue a government would be the same as allowing a citizen to effectively sue itself. Those days have obviously changed. So beginning with and following on what many of you may have heard about was the Donahue and Stevenson neighbor principle back in the 30s in the UK, there developed the common law of negligence, where effectively you had a duty to look after your neighbor. So you had a duty to take reasonable care. So then the case law developed as to how that might apply to public authorities. And in Canada, the leading case in that respect is a case called Just and British Columbia. And that was a case where a plaintiff sued the British Columbia Road Authority for failing to properly maintain, inspect rock faces along highways, I think leading up to Whistler. And in that case, which is very much front and center in the City of Nelson and Marchie case, the Supreme Court of Canada addressed common law liability for negligence of a road authority. And it determined that, yes, in modern times, it is appropriate that a person be able to sue a public authority for negligence in respect of efforts that they are alleged to have undertaken in a fashion that was not up to an appropriate standard of care. But the Supreme Court of Canada also recognized that there has to be room for public authorities to be able to make policy decisions that are immune from review from courts. It's obvious that governments have limited resources. They have to make choices. There are political decisions that have to be made. So the court in British Columbia, while it recognized that there was a duty of care of a road authority to a person injured by virtue of the road authority's failure to perform operations, the court also recognized that there has to be some realm that a government is free from being sued. And it spoke of this realm being policy decisions. And in respect of policy decisions, those kinds of decisions would be left to the ballot box. So going forward, we have the public authority liability at common law. If the public authority undertook operations and performed them in a fashion that was below a reasonable standard, it could be held liable. But it's important to note that in addition to that stream, the common law negligence stream, there's also a stream of statutory negligence, if we can put it that way. And frankly, that's more the regime that applies in Ontario. In Ontario, under the Municipal Act or City of Toronto Act, there is a statutory obligation upon municipalities to maintain roadways in a reasonable state of repair. So the statute creates the duty. It's not the common law. There's no search as to whether the common law duty has to apply. The statutes in Ontario already indicate that it does. So that's effectively why we say this Marchie case, when it starts to speak of what the true meaning of pure policy decisions are, it will not have a huge impact, at least insofar as Ontario is concerned, in terms of liability for maintenance of roadways, because the legislation creates that liability. The Ontario legislature has already said that all municipalities have an obligation to maintain roadways in a reasonable state of repair. So it's not open for road authorities or municipalities to argue that, no, we shouldn't owe that duty because what you're really attacking is a pure policy decision. The legislature has already determined that the duty exists. So the applicability of this decision is going to be relatively minimal in Ontario, in our view. Sarah, if you can just go to the next slide. And Sarah's going to get more into this as she explains the City of Nelson case. But after the Justin BC case that I spoke of, there has been an ongoing debate for the last number of decades. Justin BC was decided in the late 80s over what is an operational decision, what is a policy decision. And the shorthand argument was there could be a duty of care owed for an operational decision, but there's no duty of care owed in respect of a policy decision. And courts recognized over time that almost any decision could be spun as operational or as policy. To give an example, using the Nelson case, was the decision not to clear snowbanks, was that a policy decision? City of Nelson argued, yes, it was. It was our policy not to do this. The plaintiff argued, and the Supreme Court of Canada ultimately accepted, no, the policy decision was in respect of maintenance of roadways generally and clearing of parking spots. It wasn't a pure policy decision to simply decide not to clear windrows. So these debates have existed in the law, And as Sarah will point out, we will get into how the Supreme Court of Canada has helped us in understanding what a core policy decision is. But again, I reiterate that in Ontario, in respect of roadways, or as we'll get into the Occupiers Liability Act, where there is a statutory duty of care that's already been prescribed by legislation, this debate is not as useful in determining whether a municipality can be sued. So Sarah, I will pass this on to you, and you can get a little bit into the facts of Nelson and Marchie.
Great, thank you, Kevin. So we're just going to review sort of the case in a sort of 1,000-foot level, but at least so that everyone's on the same page in case you haven't had a chance to read through it yourself. The underlying facts are relatively standard and not that interesting. Nelson, like many municipalities, has both written and unwritten policies with respect to how they conduct their winter maintenance. In response to a snowfall event in January of 2015, they looked at the conditions, performed winter maintenance, and called out their winter maintenance individuals, and that included the clearing of these sort of angled parking stalls along Baker Street, which is a sector of their downtown core that does have relatively high pedestrian use. Again, nothing unusual about this response. It's how they typically or routinely would do their winter maintenance in this area. But what they would do is they would plow the angled parking stalls in a way where they push the snow up against the top of the stall, thus creating a rather large snowbank in between the end of the parking space and the sidewalk. The following day after the snowfall event, the plaintiff parked in one of the stalls, and instead of sort of walking along the roadway to gain access through the sidewalk, did attempt to traverse the snowbank and unfortunately was injured. She subsequently brought an action against Nelson in negligence, and the only live issue was liability. Damages were agreed upon. In its defense, it's no surprise, the city did argue that it owed no duty of care at all to the plaintiff because its winter maintenance decisions were core policy decisions and thus immune from negligence claims. So at the trial level, the court agreed with the city and found that the city did not owe the plaintiff a duty of care because its winter maintenance policies and sort of the decisions it made thereunder and in accordance with that policy were protected by core policy immunity. The court did consider at the trial level in the alternative arguments with respect to standard of care and causation, but it's quite clear that those findings are very colored by the finding ultimately that these are protected core policy decisions. And ultimately, the trial judge essentially says the plaintiff assumed the risk in trying to cross the snowbank and the city can't be blamed for that decision. On appeal, the BC Court of Appeal found that there was a sort of key flaw in the trial judge's analysis of core policy immunity, which is what Kevin has been alluding to. And to be honest, a not uncommon flaw in a lot of these analyses, which is the failure to separate what is actual policy and thus potentially protected by core policy immunity from what are more operational or routine decisions that are subject to claims in negligence. And the court found that, not only was that analysis flawed, but that really did color and alter his analysis, the trial judge's analysis rather, of causation and the standard of care, such that, a new trial had to be ordered on the issues. In setting out their duty of care analysis, the court recognized that this is a common law negligence area. So they go through quite a background with respect to the appropriate factors for recognition of a common law duty of care, foreseeability of harm, the ANS test, things that we know is sort of the base grounding of those streams of negligence. The court then goes on to consider whether there are any applicable established categories in the jurisprudence that would lock in this duty of care. And as Kevin had already mentioned or alluded to, this falls within the bounds of the just decision. So the just decision is a 1989 Supreme Court decision. Essentially in that case, the plaintiff did seek damages for personal injuries when a boulder fell off of the public shoulder and onto his vehicle. And so the courts have already recognized, and in cases subsequent to that, that there is a common law duty of care owed between governments to maintain and inspect the highway, and that is owed to road users. But as Kevin has already mentioned, there are these two exceptions, and the only applicable exception in this case is immunity for true policy decisions. And what's interesting about sort of this analysis is it's not a recognition that there's no duty of care. It's that essentially there is a duty of care, and then if you can put yourself into one of these exclusions, that essentially invalidates the duty of care owed in that specific circumstance. So the meat of the decision really focuses on setting out the principles with respect to core policy immunity defense. And what's very interesting is the tone of the discussion and the decision. It really is clearly focused on trying to make it easier for courts to distinguish between these protected core policy decisions from these more operational government activities that attract liability and negligence. And so the court openly recognizes that there have been some inconsistencies with respect to this application and the scope of core policy immunity in the jurisprudence. They cite several cases in which, even they go so far as to take the position of interveners as being sort of inappropriate or an unwarranted expansion of the principles to create a more blanket protection than is actually intended to be required. So they go through the time and review the history and the rationale for the defense, and they note that this is a balancing of constitutional powers. That is really what it's meant to protect. These are not small scale decisions. These are decisions such that the courts should not have the ability to interfere with governmental decision making. So they have to be on this scale. They also review a number of the historical cases to sort of glean out these principles that have been used by courts correctly to decide, what is the nature of a governmental decision and how do you separate those actual policy decisions from operational decisions? And those are the 4 factors that are shown on the screen. It's also interesting to note that the court really considered the lens of the analysis and the scale. So in this case, Nelson's argument was quite broad. They focused on, it's their written and unwritten snow clearing policies as a whole that should be really protected because they are core policies. And thus, the individual decisions made in accordance with that policy would sort of be protected under that umbrella. And the trial judge, for his part, also took that very broad view and sort of the analysis and said, okay, well, is that considered a core policy decision? The Court of Appeal and both the Supreme Court of Canada said, that's much too broad. You can't disguise everything under that umbrella. You really have to look at the specific decision being made and whether or not that can be said rather to be a core policy decision. So in this case, it's the decision to clear snow at these parking stalls on this street and creating snowbanks without actually doing anything to clear them or create an access to the public through them. That's the decision that you have to consider and whether or not core policy immunity protects that specific decision. And ultimately, that specific decision could really not be said to be protected by the immunity defense. The city did try to put into place a number of budgetary concerns on why they put forward this decision, why they can't go around and clear windrows, and try to make the decision seem in effect a bit larger than it was, when really the evidence showed this is just how things are done. It's a routine matter, of course. This is not a higher level decision that's made. There wasn't even necessarily a lot of thought. It's just a routine decision that they would do often and usually when the parking stalls are cleared. And so the court found that that's just not rising to the level of what could be considered core policy decision making. And they go on to so far as to say, even if you could categorize the snow clearing policy in general as a core policy, that doesn't mean that this specific decision, in this case with respect to the creation of snowbanks without clearing pathways for the public, that can be considered a matter of core policy. It has to be the specific decision and whether or not that's protected. And that specific decision in this case is one that's readily reviewable on objectifiable criteria by the court. And again, is a routine operational decision, not a high level decision making that should be protected by the immunity defense. The court does sort of more briefly recognize or discuss these issues of both causation and standard of care, as those were issues dealt by the Court of Appeal as well. But again, these are dealt with very briefly at the end of the decision. But it's important to note that with respect to standard of care, the court does agree with the Court of Appeal to say the trial judge really colored his analysis and using the core policy defense to essentially replace the reasonableness standard, and they say that's not appropriate. The reasonableness standard can consider some of these same factors, but it's still, that is the test at issue. It's not whether or not this is a core policy decision and that was followed in accordance with that policy in this case. The court reiterates again that the reasonableness standard is the one to be applied regardless of whether or not it's a government actor or a private entity. The test is the same, considers factors such as foreseeability of harm, neighboring standards of what other municipalities are doing. And all of those considerations have to go in, as opposed to this is just how Nelson usually does it, and it did it in this case. The court ultimately was asked to and invited by the plaintiff to make findings on the issue of standard of care and causation, but declined to do so, given the fact that this just requires a number of factual findings that it is really not in the best position to make. And so a new trial is ordered on these issues. And that's really important. And in many cases, I think a bit of what is being missed by the headlines and by a number of individuals who were sort of reporting on the hot topic of this case. Other than core policy immunity defense, there is really no commentary on the standard of care to be applied in the specific circumstance, or whether or not the city could be considered negligent. The city it's not commented on in the decision whatsoever. It really goes back to a new trial on that issue. So this does not sink the city. It just says the city has to go back and fight on the reasonableness standard and the causational issues that it ought to have done at the trial level, and ultimately, unfortunately, were colored by the trial judge's analysis. So again, the city isn't sunk. It's just saying this defense is not available. Go back and fight it on reasonableness, and go back and fight it on causation, and have that be the decision that's considered here and the ultimate finding of liability. Just going to turn it over to Kevin as well to review the Kennedy decision, which is another one that is sort of very much at play in our review of statutory liability and negligence. Oh, Kevin, you're just on mute.
Pardon me, I'm on mute. Apologize. Thanks, Sarah. This decision is, I think, a leading example in Ontario of what I had referenced earlier about the stream of statutory negligence. And this is a decision involving a claim against the Waterloo County Board of Education from 1999. And it's a decision under the Occupiers Liability Act. So it's not having to do with roadway maintenance. But as many of you will also know, under the Occupiers Liability Act, an occupier of premises has a statutory responsibility to maintain those premises in a reasonable state of repair. Now, some of you may also know that the Occupiers Liability Act in Ontario specifically does not apply to roadways. That's true. But then we get back into Section 44 of the Municipal Act, where the municipality is under an obligation to maintain the roadway in a reasonable state of repair. So they're somewhat corresponding duties under the Municipal Act or the Occupiers Liability Act. But in Kennedy, we're dealing with just the Occupiers Liability Act, because this was a circumstance where a car ended up driving onto a playing field and hit somebody. And it may actually have hit a bollard on the way. And there was an argument advanced by the Waterloo Board of Education that the presence or absence of these bollards was a policy decision. And because it was a policy decision, there was no duty of care in play. And the Ontario Court of Appeal said, no, you've missed the point here. Because the Occupiers Liability Act creates a statutory duty of care that applies to occupiers of premises, we don't get into the analysis of common law negligence, whether there's foreseeability, proximity, and then if there is, whether there's a core policy decision that can defeat the duty of care. The Ontario Court of Appeal said in this case that the duty of care is created by statute. So we don't get into the discussion of core policy decisions defeating the duty of care. What we have to look at, and this will be the same under Section 44 of the Municipal Act in terms of maintenance of roadways, we have to look at not whether the municipality owes a duty of care, it does by statute, but whether it met the duty of care by being reasonable in the circumstances, including the character and location of the highway or bridge, or under the Occupiers Liability Act, whether an occupier took reasonable care in all of the circumstances to maintain the premises in a fashion that was safe. So that's really the core difference between these two streams. And while the Marchi case gives very good guidance on what a core policy decision is and is not, it will have limited application in those circumstances where governmental authorities owe a duty of care by statute. It will still apply in Ontario where there is no duty of care by statute in those few circumstances, and some of them come up in the policing realm as to whether investigators owe a duty of care, for instance, in respect of investigations of crime. There have been very limited circumstances where a duty of care has been found to be owed, and that's an analysis on the common law basis. But in those instances, there is no statutory duty of care in the Police Services Act. So there will be some application of Marchi in Ontario, but only in those circumstances, in our view, where there is no statutory duty of care prevailing. And it's interesting to note that in British Columbia, there is not a statutory duty of care in respect of the obligation to maintain the roadways. They rely on the common law duty of care. So we think fundamentally that this decision, as much as it may have received a lot of notoriety and caused people some concern, it's likely to have limited impact. One thing that I think we will see, and it's somewhat of a small piece in the decision, is the reference, and Sarah mentioned it, when the Supreme Court of Canada talks about the standard of care analysis, which they don't spend a lot of time on, but they do say that it's important to look at what other municipalities do in assessing standard of care. And that can be a bit of a challenge, because depending upon the size of the municipality, the circumstances of it, whether you're comparing apples and oranges, that can be a challenge to determine whether what's done in another municipality is a legitimate guide for what should have been done by the municipality who's being sued. So I wonder if we may see a little bit more of that than we have already in Ontario in terms of trying to compare different approaches in terms of developing the standard of care. So Sarah, I think we'll move to the next.
Yeah, I think, and we're happy to open this up to a discussion and a Q&A with Thomas at this point, and get a bit more, I think, into the nitty gritty of where, we might see changes, obviously any questions that the audience may have, but at least start with that panel discussion with Thomas.
Sure, and thank you very much for that, for the presentation, Sarah and Kevin. Let's see, why don't we check? We have one, I think this is a comment so far. Let's see, it is from Robert Burley. In my previous role, we would have holes punched in the windrows at specific locations to allow vehicular passengers access to the sidewalk, to avoid those now pedestrians from walking along the roadway, especially during snow operations. I'm surprised that the municipality would not review this and do something.
That's probably a fair comment.
Yeah.
I suspect that many of you deal with every winter is there is only so much that can be done. And in this instance, as I understand the facts, the snowstorm had been significant. It had occurred relatively soon in terms of when the accident took place. So the initial operations were to just plow the areas where the parking occurred, and they didn't have the opportunity to dig holes through the windrows to allow access to the sidewalks, which is almost by definition more of an operational issue. It's difficult, and the Supreme Court just didn't accept that that was a policy determination. It wasn't at the kind of high level where you would have a debate over this in city council, for instance. This was an operational issue. And the court wasn't saying that because it didn't happen, as Sarah pointed out, the municipality is liable. But the court was saying that in order to determine liability, you have to have an assessment, a factual assessment on these facts as to whether something should have been done. And I think it's fair to say operationally that, and you run into this, at a point in time when it's very close to the end of the storm, simply plowing the road and getting it done is perhaps all that could reasonably be expected. But the more time which passes, between the storm and not allowing access through Windrows if there is parking in the area, that becomes more challenging to describe as reasonable. And that's where I think you run into more issues.
I would also add, there's actually quite a limited case law with respect to windrows and snowbanks in general. It's not something that's actually been litigated as often, and we deal with this, for example, on municipal bylaw streets where you might have roadways that are cleared and then those present snowbanks in between a sidewalk and a roadway that a pedestrian, by even at a crosswalk, would have to sort of deal with, particularly if an adjacent property owner isn't clearing it. I know that a number of individuals were actually looking at Nelson to see what the court would say with respect to, what ought to be done in cases where snowbanks or windrows are created by the virtue of snow maintenance. And so it'll be interesting as well to hear, when a new trial is ordered and if it proceeds, if the matter is not resolved otherwise, what the court may comment on that issue. Because there is very limited case law on what should be done in those circumstances, particularly in an adjoining roadway to sidewalk situation.
I noticed there's a question there from Scott Barry about the policy did not allow for snow removal at the parking spots. As I understand the decision, Nelson's policy was in fact to come along, as it is in many municipalities, and remove the windrows altogether at a certain point in time afterwards. But that issue wasn't really being addressed by the Supreme Court of Canada as to whether that's appropriate, because Nelson argued that they didn't owe a duty at all to this person because of the core policy decision. So the court doesn't really get into any kind of analysis of, well, would it have been reasonable to come along 5 days, 2 weeks later and remove windrows? Is that enough? So that remains to be seen, whatever happens at the next trial, if there is one.
Okay, so I think that answers. So Scott had kind of thrown over 3 comments there. Okay, so why don't we move on to Christian's question. Is there no responsibility for the plaintiff to assume the risk of walking over the snowbank as opposed to walking where access to the sidewalk was available?
Yes, there is, and that's a good question. Then the court threw that back. There's 2 concepts that come into play. One is this notion of voluntary assumption of risk. And at law, voluntary assumption of risk is a complete defense. If a plaintiff is found to voluntarily assume the risk, the defendant's not liable. But the Supreme Court has said, and they reference in this case, to voluntarily assume the risk, to be held as a plaintiff to do that, you have to be seen to be waiving the physical and legal risk of your activity, which is exceedingly difficult. It's effectively signing away your rights. And the reason the test is so high is because it's a complete defense. The better argument and the more successful argument will be the plaintiff owes a duty to look after themselves. They owe a duty of care to themselves. So the plaintiff can be held liable for contributory negligence. And the court threw that issue back to the trial, that yes, it may be a perfectly legitimate argument to make for a municipality to say, look, you saw the windrow of snow there, you decided to climb over it, you could have walked down the street to a place where you could get onto the sidewalk, and you didn't take care for yourself. That then puts a court in a position of apportioning liability and saying that both of those actions were a cause of the harm. Where is the relative degree of liability? Is the municipality 50%, 25%, that sort of thing? It's a more acceptable argument, contributory negligence, than the full-on defense of voluntary assumption of risk.
Okay. Next question is from Richard. Is there a minimum maintenance standard in BC similar to what is in place in Ontario? And do you anticipate changes to the minimum standards here as a result of the case?
I don't believe there are minimum maintenance standards in the same way as in British Columbia. And candidly, I don't anticipate that because of this case, there would necessarily be a change to the minimum maintenance standards, because the court wasn't addressing the actual issue of, does there have to be a punch out in a windrow of snow? The court was addressing itself to whether a duty is owed in the first place. And in Ontario, that duty is owed. The statute says so. And this decision is not, now I think it'll be thrown up at municipalities as saying, see, this means you have to punch out a windrow, you have to punch out a path in a windrow, but it doesn't say that. When you read the decision, it simply doesn't address that issue at all. So I think that's going to be a discussion that Good Roads and the province can have as they have ongoing discussions about what the minimum maintenance standards should look like and how they should change, if at all.
Okay. Our next question comes from OGRA Director Chris Angelo. Many municipalities have downtown cores that have parking stalls, and windrows are always created during winter operations. A lot of us clear these windrows maybe a day or so after a storm event. In this case, I understand Nelson didn't clear the windrow the day after. Is this a new standard now that the windrow must be cleared right away? What about windrows adjacent to sidewalks?
Yeah, and I'm happy to help with this one as well, Kevin. But I think, again, it has to be, very clear. You are going to have this case likely thrown at you to stand for that principle. And that is not at all what was found. There is no new standard with respect to windrows. And in fact, this doesn't really assist us in understanding, whether or not there would be liability for windrows, because the trial judge is the only one that really considered that. And, he was overturned at both upper levels of court. So I think, again, this is not to say that there could not be liability. It's just the fact that this court decision just does not assist us with respect to those issues. The case law dealing with snowbank liability and particularly like liability as between parking stalls and sidewalk access, as well as sidewalk to roadway access at crosswalks, is a live area. It does not have an abundance of case law. So the Nelson decision was of particular interest when it first came out a couple of years ago on that issue to say, oh, we might be in trouble. But subsequently, that trial judge's decision has really now faded into the background, given that it was overturned at at every level. So I think it's not to say that there isn't potential areas of liability there. It is very factually dependent. For example, there should be considerations with respect to, what are the safe alternatives for pedestrians to access the sidewalk? I mean, there's obviously at least some indication that there's foreseeability pedestrian users will be parking there and will need to gain safe access from the parking stall to the sidewalk, and sort of what's being provided. It's not maybe reasonable to expect a pedestrian to walk along a busy roadway where they might risk being hurt or slipping and falling on the roadway and becoming injured, maybe several, hundreds of meters before they can gain access to the sidewalk. But it's sort of going to turn on, what is the foreseeability of risk of harm? What are the specific circumstances? Is there clear and safe access otherwise to the sidewalk that the pedestrian might have access to? And then, that will inform the reasonableness of the pedestrian's decision potentially to try to traverse the snowbank rather than risk, walking along a busy roadway and getting hit by a car, right? So there's a lot of factors that go in there. Again, I think we're all very interested to see if the Nelson decision is heard on the merits to potentially provide some additional information about that. But as of right now, there is no, this does not change or set any clear principles with respect to there is clear liability for snowbank formation.
Yeah, I think what you're going to find is in certain areas of municipalities, for instance, a business area where there are a lot of parking stalls created and plowed out and parking meters, and it's a commercial area, that's more likely to be an area where a court's going to expect that there be something done to allow access to the commercial area that the parking's provided for. Now, under the Municipal Act, you have to be reasonable. So what is reasonable? Can you be expected on a giant storm day to clear out those windrows right away? I think a very good argument is no. After a week or so, probably. Whereas if you're looking at a windrow along a residential street, I'm not sure that there's going to be much of an obligation at all to clear out a passage through a windrow simply because people might park along a residential street. And that's kind of where the whole reasonableness argument is kind of where what we might look at as policy arguments, the kind of policy arguments Nelson tried to make. That's where they better fit. That they're, if you want, forget using the word policy. How about reasons or common sense? It's just simply not practically feasible for there to be a punch out in a windrow immediately after you've got your plowing operations in place. And it's appropriate that a municipality prioritize its plowing operations from an operational standpoint, that it focus on the major cleanup, and then it come back and deal with things afterwards. And that's where I think you're going to see the so-called policy arguments come into play in terms of what is reasonable in the specific fact circumstances.
Okay, so let's move on to the next question from Tushar. And this one, it's a little bit long, so just bear with me for a sec. So how does this case work with the lenses of upper tier and lower tier municipal infrastructure maintenance responsibilities? So kind of like, for example, on-street parking is cleared by upper tier municipalities as part of their winter snow plowing operation. However, the abutting sidewalks are under the jurisdiction of the lower tier local municipal partners, for which they're responsible to provide services to the same. Where would the material on site and agencies who contributed to such snow storage hold in court in a court case? I'm assuming upper tier municipality does not have windrow clearing services as part of their council driven services.
The short answer is the case doesn't help. It doesn't really address the issue, as you're only dealing with a single tier municipality. And again, it doesn't really speak to whether there has to be a punch out in the windrow. This is a good question, and I don't have a tremendously solid answer for you. If the upper tier municipality creates the windrow, and it is the local municipality that has the obligation for the sidewalk, who's responsible for allowing access? I think the practical answer may well be that there should probably be a discussion between the upper and lower tier municipality as to who might legitimately perform this function and how, and document it. But the case really doesn't help in that respect. And I know that's not a tremendously solid answer. But in this instance, I suspect a court would look at, again, what's reasonable, the timing, where are the resources, did the municipality speak to each other?
Mm-hmm.
Okay, this next question is from Roslyn. In Ontario, is it reasonable enough to document timing of planned winter operations, i.e. roadway cleared first and clearing of windrows created by road maintenance operations when resources are available? Does that provide sufficient defense for statutory responsibility under legislation?
I would certainly argue it should. Like in all of these cases, it's going to be a function of whether what you document as your approach actually occurred, and that becomes a challenge. Most municipalities have a good plan. The question is whether the plan actually was accomplished in any given case. But as long as you're certainly further ahead if you have an articulable plan that you have purported to follow, and it makes common sense. And I think if you're focusing on the cleanup initially, it makes good sense. You're focusing on arterial roads, hills, all those good things, makes good sense, and you can explain. It's a week or two later when things have still not occurred that it becomes more challenging. But there may be reasons why something wasn't done in a given case. So I think the argument, I'd certainly like to make it, that the planned winter operations, assuming them to be reasonable, in my experience, municipalities typically are, and as long as they're followed, that should be a good defense.
Yeah, and I think Kevin touches on a really good point, which is that courts often don't have an issue with the municipality prioritizing certain areas as higher priority in terms of a maintenance rollout. The issue really becomes when there is a large gap or just no attempt to deal or address with other areas. So, maybe a 3-day delay between when roads are done versus sidewalks, or in this case, if windrows just don't ever get done, that I think begins to pull at the strain of reasonableness in the court's case, because you can't justify that it wasn't done maybe as easily as you can justify, oh, well, we waited until priorities were addressed and then had to deal with it.
Okay. Next question is from Brian Lewis, who's a OGRA second vice president. I'm loving the turnout here from OGRA people. Could the municipality rope off the sidewalk along the parking spaces to specifically deny access to the sidewalk directly from the parking spaces?
I think that would be a worthwhile option to consider. However, you're also going to have to look at where a driver then goes. So if a driver then is left walking out into traffic, that creates its own problems. So, I know people hate hearing this from lawyers. It depends. If there is a means by which if the municipality creates the parking space, particularly meters it, and then they rope off the sidewalk, if there's a place for the pedestrian to safely go to get onto the sidewalk and to get where they're going, then I think you may have a good shot. If it simply leaves the pedestrian walking out into traffic, I think you may have a problem.
Okay. Our next question is, if a municipality inconsistently clears windrows adjacent to parking stalls in a commercial area after a winter event, is it prudent or imprudent for the operational policy to state at what height, within what timeline, and to what degree the snow is removed? Complete removal versus pathways, etc. Does each municipality need to define what is reasonable?
I'd be disinclined to try and establish a set of guidelines that provides, for instance, measurements, width of a pathway, height of a windrow, because practically speaking, you're never likely to have the degree of inspections that would allow you to create evidence that meets those standards. I think I'd be more inclined to look at things like within a week, if that makes some sense. And it may not make sense for a very heavily commercial area or a larger municipality, but to be more general so that it's been approached. There may also be some utility in advertising, frankly. Municipalities, if they can articulate that warnings, whether they be on websites or if they had the resources to advertise to a degree for people to be careful, to take their time, to not climb over windrows of snow. Those kinds of efforts may be useful as well. But I wouldn't try and articulate precise measurements and that sort of thing, because you will get held up on the fact that, well, in this case, you didn't meet it. That was your own standard. You didn't meet your standard. And that becomes its own problem.
Okay. When dealing with statutory duty of care, is there room for a policy defense for Ontario road authorities?
In terms of arguing that you do not owe a duty, I don't believe there is. The Municipal Act says that a municipality has a duty to maintain roadways in a reasonable state of repair. So this core policy defense, as it's used in the common law negligence, defeats the existence of a duty of care. And that Kennedy and Waterloo case, the Ontario Court of Appeal, has said you can't do that. Where the statute creates a duty of care, you can't make a policy decision that makes it go away. And I believe that's how the law would play out in Ontario.
Okay. Now, does this decision change the law with respect to core policy immunity?
Yeah, I'm happy to take this one, Kevin.
Yeah.
I think it doesn't change the law. It certainly clarifies it. And I think, what's really helpful is the review and the decision of sort of the underlying rationale that should inform the core policy immunity defense. And it's clear the court is trying to sort of wrangle in some of the other strains and views and arguments that have emerged in the last several years. And practically speaking, I mean, if you really think about it, the decision that Nelson was trying, or they were trying to get, was that their winter policy was immune from, negligence claims. That is a very broad reaching argument. If you think about the fact that, any decision they're under would then be protected, which essentially immunize them from the majority, if not all, of negligence claims arising out of winter maintenance. That's a very high argument to make, and a harsh thing to sort of put on pedestrians and road users. So I think, again, what's helpful here is, the court really does articulate the policy and the purpose behind the core policy immunity defense. They want to maintain the separation of powers, and you have to look at that scale. That's what's important. There, the balance and checks and balances that are be there, and those are the decisions that are to be protected. So, the court identifies these new hallmarks. I think they set out a good framework and sort of, streamline how this process is to be undertaken in the future. But really, again, not a major shift, just potentially a reorganization and a bit more of a concrete and assistive framework for those defenses going forward.
One thing it should note, and the court addressed this, was Nelson's winter policy. They called it their winter maintenance policy, and then they argued, because it's our winter maintenance policy, it's a policy decision, therefore it's immune. And the court said, no, you can't just, it's not about what you call it, it's about what it actually is. The true policy decisions are made at a high level. They involve debate. They involve high-level decision makers. You can't simply have a plan, call it a policy, and expect that this defense will work. Similarly, if it involves budgetary considerations, they had better be very high-level budgetary considerations. Almost every operational decision does involve some level of budgetary considerations. How much are you going to spend this week? That sort of thing. The smaller level, if I can put it that way, and the court addresses this, the sort of operational economics, those are not economic decisions that attract the policy defense. They're not the kind of broad governmental determinations of where you're going to put resources. If it's a matter of how much you're going to pay for a bucket of salt, that's not the kind of economic decision that attracts a policy defense.
Okay, so, and we have a follow-up question to this. So a core policy defense does not work in Ontario, where we have a legislated duty of care?
Not if the argument is attempting to defeat whether the duty of care exists. The policy argument may be better used in arguing what is reasonable in the circumstances. But Kennedy and Waterloo says that you can't defeat the existence of a statutory duty of care by making a core policy defense argument, because the legislation's already decided the duty of care exists. But where many of the same arguments can be made is in assessing what is reasonable in the circumstances.
So again, it's not losing those key arguments. They still come into play in our arguments that we've been reasonable in the circumstances, we've met the standard of care. Those arguments are still there. It's just not under core policy immunity, which would invalidate a duty of care. It's saying, look, we acknowledge there's a duty of care and we met the standard in this case.
Similarly, the court does recognize that there can be legislation by the province that says there is no duty of care. So you have circumstances, and we'll see how it's going to work. But for instance, in the long-term care facility and the COVID legislation, there are some provisions that the legislature has tried to implement that say there is no duty of care for certain things. And where the legislature has legislated that there is no duty of care, the common law negligence has no, or analysis has no place for a foothold, because the legislature has already decided that a duty of care does not exist. And the court in the Nelson case recognizes that that can also be the case.
Okay, and I think we have one last question here, and this one actually kind of nice sums everything up. What impact, if any, will this decision have in Ontario?
Sarah?
I think in the municipal context, I think we can safely say, to be frank, it's going to be likely thrown in your face, but in reality, there's not a lot of difference here. We generally are not advancing core policy immunity defenses in our winter maintenance cases in which we act for municipalities. It's not one the Ontario courts have ever really been live to or interested in. The duty of care is there, it's legislated. Our legislation prescribes a standard of care, and the real fight is, did you meet the standard of care? What were your policies? Are they reasonable in the circumstances? And how you acted, was that reasonable given all the factual matrix at issue, or at hand rather? So ultimately, there's little impact, if any. You're likely going to see the case be, maybe brought to your attention. But I think again, and what we've said internally is that maybe speaks more to that person's awareness of municipal law than it actually does to the value of the case in Ontario. The municipalities are still, we have our prescribed duty of care, and we're still focused on the reasonableness standard under our prescribed maintenance standards. And that's really where the fight's going to be. It's not going to be on core policy immunity.
Okay, and we have one last question, like maybe a minute to answer this. To add to Tushar's previous question, what if the upper tier has a core policy that it does not perform snow removal, and the lower tier has a policy and does perform and has performed snow removal? Would this help be a defense for the upper tier in litigation?
I suppose it may, but what you're going to run into for the upper tier, assuming it's an upper tier road, is they have an obligation to maintain the roadway in a reasonable state of repair. And the question is the windrow part of that obligation? And they may have, so I don't know that they can make a core policy decision. It's not going to defeat the existence of the duty of care per se, because that exists by legislation. But what it may do is they've decided this is what we're only going to do this much, but we know the lower tier municipality does these things. Look at all of that, and what we determined to do was reasonable in the circumstances. But ideally, there would be some engagement between the upper and lower tier to work that out.
Okay. Well, there we go. We've answered all the questions, and we have we're pretty much at the end of our time. So I think this kind of worked out perfectly for us. So this concludes the morning's webinar. Kevin, Sarah, thank you so much for taking the time out of your busy schedules to talk about this very important issue, and for putting together this presentation. And thank you to our audience for joining us today and taking part in this. I hope you all learned something. I know that I did. So take care, everybody, and have a wonderful day.
Okay. Thanks, everyone.
Thanks, everyone.
Okay. Take care.